The court should order Caleb to vacate the residence.
You need to find a place to move your stuff to and get out of there. Say whatever you want today to try to buy more time, but the reality is you've had 3 years. This is in the District Court of Butler County, Kansas. Case entitled in the matter of the marriage of Brianna M. Kirkpatrick and Caleb B. Kirkpatrick, case number 2021 DM 135. Brianna, the petitioner in this case, appears with her attorney, Stephen Turley. Caleb Kirkpatrick appears by Zoom, apparently representing himself at this point. Mr. Kirkpatrick, we're here on a motion for contempt of court. You're not represented by counsel here?
I tried to get a lawyer and they never called me back. I called them like 4 times.
All right, Mr. Turley, has there been any resolution of any of the issues that were raised by your motion?
No, there hasn't.
Turley, are you aware that that there is the Secretary of DCF through their contract attorney is enforcing child support?
I'm aware that they purport to be doing that job, but they haven't, and the most recent effort will be a complete waste of time.
And why is that, Mr. Turley?
Because Mr. Kirkpatrick is self-employed and all they have done is filed a new notice to issue a new income withholding order to Mr. Kirkpatrick, who already has the copy of the court order that he's not following.
Anything you want to say about that, Mr. Kirkpatrick?
Yeah, I mean, basically I lost about half my income this last year. And I'm currently, my taxes should be done here in the next week or 2. So I just haven't been able to afford the $1,000 a month in child support.
Well, if your business isn't successful anymore, Mr. Kirkpatrick, why don't you go to work for somebody else?
I am currently also looking for a part-time job.
All right.
And I'm also doing, I just started my VA disability claims, and I'm waiting for my medical records to get issued to the VA.
All right. While this court is hesitant to conduct a hearing of this nature by Zoom, that's what we have scheduled, and we'll go ahead and proceed with evidence, I suppose, Mr. Turley. Are you ready to present evidence at this time?
We're certainly willing to do that, Your Honor. If I might just make a few comments about how I view things procedurally at this point, and then we can go from there.
Very well.
So before the court are a few different issues, and there is overlap amongst all of them. But the general problem is that Mr. Kirkpatrick's house is not in order, and I mean that figuratively, not literally, but he is over $20,000 behind in support, as Your Honor has seen from our affidavit. He has not refinanced the mortgage. He has not paid the equalization judgment. He's basically disregarded most of the agreed upon journal entry of judgment and decree of divorce. And I think there are some issues in our motion that may be and should be resolved as a matter of law, and then others for which the court would need to take evidence. If the court wants to take evidence today, we're ready to proceed. If the court doesn't, wants to set this over to another hearing in person at the courthouse, we're comfortable with that as well, whatever the court prefers. As to the issue that I think the court can resolve as a matter of law, Mr. Kirkpatrick was awarded the former marital residence subject to a lien for the property settlement judgment, and he was ordered to pay that judgment and refinance within a year of July 19th, 2021. We're now September of 2024, and neither of those things have been done. And the decree provides on page 12, quote, "The marital residence shall be sold default if the note and mortgage is not timely refinanced or extinguished. The court retains jurisdiction to enforce the terms of this paragraph. Caleb shall pay and satisfy the equalization judgment due to Brianna before or at such time as he refinances or extinguishes the note and mortgage pursuant to this paragraph. And of course, the bank is going to require that all judgments be paid anyway to close on any transaction. And so this decree incorporates a settlement agreement, which is not subject to modification and must be enforced by the court upon request under Kansas law. And therefore, as a matter of law, the court should order the sale of the former marital residence and the equity to be liquidated to pay all judgments. As to whether Mr. Kirkpatrick is in contempt or not, whether my client should be granted sole legal custody, and whether parenting time should be modified, I would acknowledge that those are all evidentiary determinations that need to be made based on evidence. And if the court wants to proceed today, we're ready to go. If the court wants to wait and do this at the courthouse another day, we're fine with that too. But we do think that the court should order the sale of the house today. And I can discuss, my thoughts on the mechanics of that if Your Honor wants, but that's the gist of where I think we are.
And how much is owed on this house, Mr. Turley?
I don't know. Your Honor would have to ask Mr. Kirkpatrick that.
Oh, doesn't your client have access to the mortgage information?
No, I mean, I do, yes, but on my behalf, it's not my house, so I do not get involved in that.
So we can look into it if you want, Judge, but she doesn't have that information.
Well, I'm just looking at the practicalities of what you're asking for, Mr. Turley. I mean, is there equity in this property? Is it worth considerably more than the mortgage indebtedness upon it?
I don't know for sure, obviously, Judge, but I can surmise and speculate that the answer is yes, and for these reasons. One, we knew what the mortgage was at the time of the divorce, and there was equity in the home at that time. Two, we have a fair degree of confidence that Mr. Kirkpatrick has not further encumbered the property because any title company would have gotten in touch with Brianna as a result of that. And number three, the real estate market, as we all know, has just in general, all things being equal, gone up since 2021, not down. So I am fairly confident that there's equity to pay the judgments. Whether there's enough to pay 100%, I don't know, but at least to pay quite a bit.
All right, before I turn to Mr. Kirkpatrick for his side, Mr. Turley, what would the mechanics of sale be here that you're asking for? I mean, first of all, you'll need to unmute yourself before you readdress the court, Mr. Turley, and then.
Yes, thank you, Judge. We say, as set forth above, Brianna has a lien against the former marital residence to secure the property settlement payments. The court should order Caleb to vacate the residence and authorize Brianna and her counsel to sell the same. Upon sale, the proceeds should first be utilized to pay all of Caleb's judgments, including Brianna's attorney's fees. So that's our proposal, is we would like the court to order Mr. Kirkpatrick to vacate the residence and put Brianna and myself in charge of selling it.
Okay, so I from that, I get the impression, and really to address the court's question, you're believing that it should be done by private sale rather than public auction, correct?
That's correct, Judge. We are not asking for an auction, but if that's what the court orders, we wouldn't throw a fit about it.
Well, I'm glad you wouldn't throw a fit about it, Mr. Turley. All right, Mr. Kirkpatrick, I think you now have a basic understanding of what's being requested in regards to this property. Do you have any response that you wish to give?
Basically, like, I'm in the current, like, I'm trying to get my taxes done, and then I'm gonna refinance my house, and then that way, then I'll have the extra money to be able to pay Brianna for the times that I've missed on child support.
The problem with that, Mr. Kirkpatrick, is if you were going to do that, you would have done it by now. I mean, hasn't it been 3 years that you've had to make this sale? The decree gave you 1 year. You've had the grace of a couple of additional years, and no sale has come about, no refinance has come about, and it seems to the court that you've had plenty of opportunity. I mean, why haven't you addressed this earlier?
I don't. I think it was more because of the interest rates, and so I just didn't want to do, have to go super high on my interest rates. So that's why I just haven't. But I will get it done.
And you're still occupying these premises?
Yes, Your Honor.
Describe the property to me, Mr. Kirkpatrick.
It's a house. It's got 2 acres, and it's kind of it's outside of Augusta, Kansas, and kind of in the country. But yeah, I basically run my business through my house. Like I have a shop and with all my tools and stuff for my business.
And what is your business exactly?
I'm a self-employed contract pumper in the oil field.
Why aren't you working for an oil company directly?
I work for it's kind of, I don't know, it's hard. It's everyone that does like my job is self-employed, and we have to work for, like, I work for 3 different companies right now. And basically what happened last year was one of my companies sold pretty much all their wells to another company that already had somebody that does my job. So I'm making way less money than I was when we started the child support and all of that.
Shirley, is there anything about Mr. Kirkpatrick's presentation to the court that would change your client's view as to how this real estate matter ought to be handled?
No, normally we would be concerned about Mr. Kirkpatrick's disruption of his tools and his home, and for a number of different reasons, but that matters not to us at this point because he's not paying child support and he's not exercising all of his parenting time either. So he's had Brianna, intent by design, gave him an extra 2 years. And here we are 3 years later. He's just not following much of anything in that decree, which is signed by a district judge. He's treating it as a suggestion rather than a court order. And we want the orders enforced. And that's what we're here to do today.
All right. Any last words, Mr. Kirkpatrick?
No, I don't have any.
All right. Again, Mr. Kirkpatrick, as the court's earlier remarks certainly suggested, you've had a lot of time to accomplish certain goals in this case to avoid the orders which the court is ready to make, but you haven't availed yourself of the considerable time opportunity that you've had to choose one of the options to get Brianna off of this house. It could be done upon you selling it and paying it off, refinancing it, somehow convincing the lender to take her off of the responsibility for the loan, perhaps by obtaining a co-signer or doing some sort of refinance that would enable her to be taken off of this obligation completely. But you haven't done that. Your time's up. The court's not inclined to grant you any more time to do it. You've had enough. And it's obvious that you're not going to do it, Mr. Kirkpatrick. You can say whatever you want today to try to buy more time, but the reality is you've had 3 years and you haven't accomplished what I think is a relatively simple and straightforward goal. And that is to get her off of the obligation of this house. Therefore, as the agreement and decree would state, the house is to be sold and the court will make an order of forced sale of this home. While I'm at first hesitant to order eviction as a prelude to that sale, as a practical matter, I don't know how the house can be marketed or ready for sale if you're in there, Mr. Kirkpatrick. And I also might get the impression that in many similar instances, you're not going to be particularly cooperative with this sale. Therefore, you need to get out of there. And the court's going to give you 30 days from today's date to completely vacate the premises and just relocate to another place. At the end of that 30-day period, the court will grant possession of the property to Brianna in this case. If property is left behind on the premises, it needs to be preserved, stored. I don't necessarily want things to be lost. On the other hand, you're taking a huge risk, Mr. Kirkpatrick, by leaving anything behind. I'm not going to say that you forfeited any and all interest, but I think you certainly risk some degree of loss for any property you don't have removed 30 days from today's date. Then at that point, she can come in, she can make whatever improvements, repairs to the property that are necessary to ready it for the best possible price of sale. And the court will order it to then be sold with all practical speed thereafter by private sale. I trust you're going to be using a realtor, Mr. Charlie.
Yes, sir.
If all judgments, and it seems unlikely to the court, there's going to be that kind of equity realized on this property to pay all back due judgments in this case. Obviously, the mortgage has to be satisfied, any tax obligations that are owed, anything else that would constitute a lien on the property first. After that, then applied to the various unpaid judgments in this case. But should there be some sort of positive amount at the end of all of that, those are just simply to be held in escrow until this court can make a further ruling regarding disposition of those proceeds. And most likely the title company that does the closing will be holding on to those funds pending any further order of the court. It's regrettable, Mr. Kirkpatrick. I would like to see you keep the place, but apparently refinance is not going to happen, or it would have happened by now. Obviously, if you can show proof by the end of that 30-day period that you have effectively refinanced the property in accord with the court's prior orders and your own agreements, the court would reconsider its order forcing you from the premises. But you've got 30 days. I think that's, in light of the time that you've already had, that seems like plenty. You need to find a place to move your stuff to and get out of there. And further, not do any damage to the property. It needs to be maintained in the best possible condition under the circumstances. It's in your best interest, Mr. Kirkpatrick, for that property to eventually get the best possible price. Charlie, I know you'll be drafting an appropriate journal entry stemming from today's proceedings.
I will, Your Honor. And so that leaves the evidence-based decisions on the other items. Do we want to schedule an evidentiary hearing on that? Or
I do.
Okay.
I do, Mr. Turley. Mr. Kirkpatrick, I'm again going to admonish you and give you advice from the bench to the extent I can. You need to be represented by counsel on the rest of this case. One remedy the court has is to incarcerate you, to hold you in jail, to compel changes in your conduct. You need to be aware of that. This is not some trivial matter. So you should seriously consider getting the advice and assistance of legal counsel in this evidentiary hearing in which I'm going to schedule. I'm going to order your personal appearance at the Butler County Judicial Center at the date and time that we establish. No more Zoom.
Yes, Your Honor.
This is strictly an in-person proceeding. Mr. Kirkpatrick, one more time, I'll advise you that you really should have legal counsel at that hearing.
Yes,
Stakes
Your
for
Honor.
you are quite high. We will address all remaining issues in the case at that time. I'll hear evidence on child support. I am hesitant to interfere with child support enforcement proceedings, which are already taking place, but I can understand the frustration, Mr. Turley. A modified income withholding order might actually be an effective remedy if he worked for a traditional employer with a payroll. For someone self-employed, it's probably almost moot. He controls his own income, and therefore the payout of his own salary and or benefits and or profits. So child support will be an issue that the court will hear evidence on. Sounds like you're very, very deficient on the payment of your child support obligation, Mr. Kirkpatrick. I do understand that there are downturns in business, but it seems to me anyone with your skills ought to be readily employable by any number of possible employers. It's just not acceptable to the court that you take the position, well, my business is down, therefore I don't have to pay anything. Doesn't work like that. So Tuesday, October 29, 9:00 a.m., Courtroom B. There'll be a further evidentiary hearing in this matter. I will note again that this is a couple of weeks beyond the 30-day period that the court has established today for Mr. Kirkpatrick to be out of the Hopkins Switch property. All right, Mr. Turley, is there anything in particular that we need to address today?
No, Your Honor, I'll prepare the order and we'll include the order back in that order.
All right, very well. I look forward to receiving it. Mr. Kirkpatrick, is there anything else that you need to present to the court today?
No, I just have one question.
Go ahead.
So I have to get out of my house in 30 days, or
Correct. You have to
I
vacate the premises completely so that Brianna can come in with whatever help she can enlist to get the property ready for sale and to sell it by private sale.
Okay, so I can't refinance. There's no.
You can. Like I said, if you can show that you have effectively refinanced the property by the end of that 30-day period, obviously there's no need for a forced sale. The whole idea is to get her completely removed from any possible liability on that house. That was supposed to take place 2 years ago.
Yes.
But it seems to the court, if you haven't been able to accomplish it by now, I don't know how you're going to accomplish it in the next 30 days. But if you can work some sort of financial magic, and that can be confirmed to Mr. Turley's satisfaction, the court would consider a different order.
Yes, Your Honor.
In fact, I'll put if Mr. Turley, I think he's wise enough to know that if that documentation, and he's satisfied with that documentation, that his client is no longer liable on that mortgage debt, I don't think his client will take any further action toward removing you from the premises. But again, I just don't know why you think you might be able to accomplish it now when you haven't been able to do it for 3 years, and you admittedly have reduced income because your business is down. Your income is down. But I think you see that we're being open-minded here toward another resolution should you be able to accomplish it. All right. I'll again ask Mr. Turley, anything else we need to address today?
Not from the petitioner, thank you.
Anything else from you, Mr. Kirkpatrick?
No, Your Honor.
Very well. And if there's nothing further at this time, this particular case will be in recess, and this meeting may be ended.